So again, I think all that example does is just reiterates the uncertainties or the debates in the scholarly literature as to what the ideal position should be, and at the end of the day, the prosecutorial practice in this area tends to leave those questions undisturbed. The third scenario, and I guess it would be relevant also to the example just given, is this issue of intermittent participation. The idea that an individual might be a farmer by day and a soldier by night. And again, it won't surprise you to know that there are two alternative views on that. Those that favour perhaps the more absolutist forms of civilian protection would tend to say that to the extent an individual oscillated between these two statuses, that protections are lost only to the extent he or she participated in hostilities, and that it's entirely it would enhance civilian protections to say that that protection was resumed to the extent that this individual took up civilian functions again. An opposing view would say that this is entirely artificial. This is an individual, for all intents and purposes, who is engaging in combat. And although I'm not aware of any direct issue on point, my instincts would tell me that an international criminal tribunal would tend towards that latter view. And in fact, I can point to something from the Strugar judgment, where basically it speaks of the accused's presumption of innocence, and to the extent if there's even a reasonable doubt that an individual may have participated in hostilities to the and it was therefore questionable as to whether there might have been some justification for an attack, that tends to weigh in favour of the accused, or to benefit the accused. What actually amounts to direct participation in hostilities? Well, the ICRC has established 3 cumulative requirements for this. I think we can all agree on the most obvious. Basically, these 3 cumulative requirements are, firstly, some sort of threshold of harm. Basically, participation in hostilities perhaps will not make the grade if it's not by its nature something that can actually inflict harm on the enemy. There has to be some sort of relationship, if you like, between that act and that expected harm, and some sort of nexus or connection between the hostilities in question and that. And the ICRC's view is that applying this criteria in conjunction, this permits some sort of reliable distinction between activities which amount to direct participation, which suffices to remove protections from civilians, and indirect participation, or perhaps support to the war effort, or the like, which of course civilians routinely engage in, but which is not traditionally thought as sufficient to remove those protections. And that is, I think, reflected most graphically in the ICTY jurisprudence in relation to the Strugar case, which was a situation in which the town of Dubrovnik was shelled, and 6 individuals were killed during that shelling, and General Strugar was convicted for that shelling. On appeal, General Strugar's defence counsel suggested that one of these 6 individuals was in fact assigned to work as a driver for the Dubrovnik Municipal Crisis Staff, and that during the attack on the 6th of December 1991, in which he was injured, he was transporting members of that crisis staff. And he argued, General Strugar argued that this individual was therefore taking an active part in hostilities, because under wartime conditions, although the crisis staff was a civilian body, it actually worked in tandem with the military. Indeed, under the law on the defence of the Republic of Croatia, provided that members of the municipal crisis staff perform military tasks in times of war. The prosecution countered that by saying that the individual in question was by no means a member of the armed forces. He was instead, to all effects and purposes, a civilian working as a driver, his mere auxiliary position as a driver for the crisis staff did not in any way meet the test of taking a direct part in hostilities. but the prosecution did nonetheless acknowledge that if this individual had been a member of an organised armed group or of the armed forces conducting hostilities, then indeed the appeal would have succeeded, and he would have indeed been a civilian who was at least potentially directly participating in hostilities, and therefore who could have been legitimately targeted under international humanitarian law. The appeals chamber, when reviewing that, basically found that there was that any notion of a required nexus between this individual's conduct of driving and combat activities at the time, and the circumstances prevailing at the time, which was basically he was injured near his home on the way to work. He was not on the way to a theatre of conflict or anything. Ruled out any notion of possible participation in conflict, which by its nature or purpose could be said to threaten or cause any actual harm to the personnel or equipment of the adversary. And in conducting its analysis of the notion of direct participation in hostilities, the ICTY appeals chamber referred directly to the ICRC commentaries, but it also undertook a very useful survey of military manuals of other states, and provided a number of illustrative examples of what constituted active or direct participation in hostilities. Clearly everyone could agree on the obvious candidates: bearing, using, taking up arms, taking part in military or hostile acts, activities, conduct or operations, armed fighting or combat, participating in attacks against enemy personnel, property, etc., transmitting military information for the immediate use of a belligerent, etc. I think just in concluding, I think that while I think that is a useful distillation analyst, it clearly doesn't sort of expand the boundaries of human knowledge in this area. And I think some issues that I think are useful to bear in mind in relation to modern combat is what actually constitutes direct participation in hostilities in relation to cyber warfare, in relation to more sort of technologically advanced forms of combat. Is an individual based in Washington hacking into the Indian defense servers, committing direct participation in hostilities, assuming that the state of India was involved in armed conflict at the time? Logic would seem to suggest so, if in so doing a cyber attack like that could actually have a bearing on the outcome of a conflict, or threaten or cause harm to a belligerent party, then it should be. But then we have a notion of direct participation in hostilities by an individual that is geographically and temporally completely removed from the theatre of armed conflict. Similarly, the interface between civilian and military contractors these days, civilians engaged by the military to carry out specialised functions in a sort of support capacity, specialised personnel dealing with military communications, for example. To what extent, where does the boundary lie in terms of those functions and direct participation in hostilities? The only echo of this that I can think of in the ICTY jurisprudence is in the NATO bombing report, which addressed the bombing of the radio and television station in the former Yugoslavia, in Belgrade rather, indicating that the civilian communications infrastructure in that context was actually heavily interlinked with the military one, and that was a so-called dual-use military objective. But very, very little actual jurisprudence to push these boundaries, and I think this is all in the realm of doctrine at the moment. So just to conclude, the other thing that is interesting in relation to direct participation in hostilities is that it raises a lot of interlinked principles that I won't go into because I think my time is well up. But basically, sort of not only are these cases involved with the determination of the status of individual civilians, but also civilian groups or populations. What happens if you have a civilian, a collectivity of civilians in which military personnel are intermingled? There's helpful jurisprudence to say that the mere presence of one or two combatants or one or two individuals of disputed status within an overwhelmingly civilian population will not suffice to convert the character of that population into a non-civilian one. But in all cases, the specific focus should be on the envisaged target of that attack. Similarly, if an attack is lawful by the standards of international humanitarian law, the fact that surrounding civilians might in fact have lost their lives and a large number of civilians does not automatically convert that into a crime against humanity. Otherwise, the fact that these different types of offences exist side by side would actually render the entire edifice of the law-abiding conflict to be unworkable. So I think on that note, I'll conclude in the hope that there might be time for some questions or general discussion. Thank you.
Thank you. Thank you, Professor Lam, for taking us through jurisprudential analysis of the concept of direct participation in hostilities, though emanating from one international tribunal in particular, touching and concerning other tribunals' interests in the concept of DPH, and from a practical perspective, your own reflections of the concept of DPH in the contemporary battlefield. Quite rightly, you referred to the cyber warfare component, which is one that is an ongoing debate, as well as the private and military contractors, the private and military security companies. There is the PMSC +5 Montreux process and document, which relates to, in part, this issue. How are we dealing with this from an international legal and jurisprudential purpose? Ladies and gentlemen, the topics have been rich. We've had the legal aspect, the strictly legal aspect. We've had the envelope pushing aspect, the practical aspect of direct participation in hostilities. I open the floor to some questions. Ma'am.
Good afternoon to all present. I'm Pari, a student from Jindal Global Law School. My question is in two parts. My first part is to Sir Parita Fernando, Ayubowan. My question is that basically how does the because you mentioned preemptive defense also being a valid form of like people engaging in certain actions, to that extent it interplays with the doctrine of proportionality, because the assumption there is that there is enough evidence, etc., that one can indulge in preemptive actions. And the extension to that and the extrapolation from that is that to that extent, because Professor Susan Lam, you mentioned that civilians specifically are only accorded these protections if the threshold for an armed conflict is proven. And more often than not, to reach that threshold, there are many stages, and to that extent, a lot of violations do already take place before that threshold is met. So to what extent is there existing jurisprudence from these ad hoc tribunals that suffices to their defense? So that's my question.
Thank you. Questions? We will take 3 questions. Sir.
My question's for Professor Lam as well. So you've discussed, for instance, how, the modalities of how distinguishing between someone who's taking active or direct part in hostilities becomes an issue, and what sort of problems are faced with making those definitions. But in terms of what sort of actions, so as Mr. Fernando as well touched upon, is that there are certain actions you have to limit. What sort of actions, the ultimate goal of IHL is not necessarily to prevent completely civilian casualties, because that may not be possible, but to make sure that the ratio between what your objective is being achieved and the damage it has caused, which it necessarily will cause in any violent action, making sure that's the highest possible ratio. The reason I bring this up is so and forgive me for mangling this name, is that late in 2012 there was an appeal in the ICTY with Gotovina and Markach, where they were talking whether the court sort of created this arbitrary instance of because the army was shelling a certain city, and any shelling that occurred outside of 200 yards from a stated objective would be considered evidence of the fact that they are not adequately trying to make a distinction between their civilian object, I mean a civilian target or a military objective. So what sort of actual jurisprudential standards exist for defining what sort of action is permissible in a certain situation for a certain type of target? Thank you.
Thank you. Sir.
This is to Sir Paritha Fernando, sir. Sir, you talked about the right to preemptive self-defense, and you also said there is some basis for that under international law. If you can cite the legal instrument, I'll be. And just one comment, sir. I find that argument to be problematic, and I can cite at least one example for that. The US has been waging a never-ending war in the name of war on terror. Now, in that war, where self-defense against the grave threat of terrorism has been invoked in order to justify so much of excesses. So there is a lot of element of subjectivity involved in that. Once you allow that particular thing to happen, then the very, in a sense, the principle of distinction and the very purpose of law, the entire body of law, gets diminished. So what are your thoughts on this?
Thank you. I just open up the final question, sir, to the back in this round.
My question regards the private military contractors that are there in Iraq. Article 4, I think, of the Third Geneva Convention makes a distinction between a nation's regular armed forces and other militia or voluntary corps of the same nation. And Article 43 of the first additional protocol defines combatant. My question is that isn't it possible to reinterpret Article 43, taking the expanded definition from Article 4 of the Third Geneva Convention and include these private military corporations into a nation's regular armed forces? Thereby we can subject them to the same responsibilities that every combatant is obliged to observe.
Thank you very much. I leave our panelists to answer the questions as our panelists deem appropriate.
I think there were two questions asked on the concept of preemptive self-defense. I think the concept of preemptive self-defense is a concept that has been discussed quite often, and also it is a matter on which there have been some scholarly articles. Unfortunately, I cannot give you the references, but I can cite you one. During this, where Israel invaded the Egyptian territory, there had been no attack on Israel by that time, but then they were able to go into Egyptian territory, and the way in which they were trying to justify their action was preemptive self-defense, because they were facing an imminent dangerous situation, and as a result of that, they are entitled to do that. Now, even in the case of the attack on Iraq, I think some of the scholars, they were trying to justify it on the basis of preemptive self-defense. That is, there is no threat on you right now, but then there is a situation that you have to preempt in order to protect yourself. But in those situations, there is no doubt that the question of proportionality comes in. Your attack, in order to preempt some sort of action against you, which is threatening you, which is exposing you to some sort of danger, will have to be proportionate. But what I was trying to demonstrate was there have been certain situations where camps have been established where there is human habitation or human population, and then attacks are launched from there. And when attacks are launched from there, and where there are civilians, whether the attackers can be considered to have acted in violation of the principles of international humanitarian law, which provides that a civilian is protected unless there is direct participation. So I think you're correct when you say that where there is preemptive self-defense, the issue of proportionality arises, and where there are a few civilians and the majority are armed, or rather more civilians and a few members of the armed forces, I don't think that the protection is lost in a situation like that. So I cannot give you any authority on this preemptive self-defense other than to say that on these occasions, that was one of the issues that was highlighted, and especially in the Israeli matter, where Israeli forces went into Egyptian territory, not when they had attacked Israel, but when they were gathering, and then there was an imminent danger according to their intelligence reports. So that's what that's my explanation.
Thank you. Professor Lam.
Right, let me be pithy given there's quite a few questions. I think just to follow on from the Attorney General's comment, one way I think around the conundrum sort of that you mentioned is to bear in mind that the so-called law on the resort to armed force in the first place, the so-called jus ad bellum, should be always differentiated between from the law of armed conflict that will apply sort of within the nature of within that conflict, irrespective of its nature. So basically, once an armed conflict is in existence, whatever its cause, whatever its legitimacy, whoever is on the offensive and the defensive, effectively international humanitarian law takes a morally neutral position, and both attackers and defenders are then subjected to the same analysis. And I think that helps. That came up in a really real way in the ICTY, where basically there was a school of thought that thought that Slobodan Milosevic's attempts at irredentism throughout the entire Yugoslavia converted the entire campaign to establish a greater Serbia into one great unlawful attack. And it was rapidly realised that that was conceptually unworkable, because it would effectively, and the reality on the ground was that belligerent forces that actually saw themselves very much on the defensive were occasionally subjected to prosecution when the means and methods of warfare they used were excessive. And Nesser Oric was an example of one of those prosecutions, albeit he was acquitted at the end of the day. The question of the threshold for the existence of an armed conflict being a serious impediment to dealing with atrocity crimes, you're completely right. It is the answer to the first limb of your question is there jurisprudence that interprets that threshold? There is. There's consistent ICTY jurisprudence that basically says that an armed conflict comes into existence whenever an armed conflict is of a protracted or organised nature. It's sought to basically explain away those elements to the extent possible. It hasn't really defined with any great clarity what degree of organisation or protractedness is required, but it does cite the ICRC's differential threshold of a riot or sort of internal disturbance of that. The way that it's sought to limit the impact of that on its work is several. It's basically said, look, in relation to crimes against humanity at least, it is a pure jurisdictional threshold. It's basically just simply a box you have to tick. The minute an armed conflict comes into existence, international humanitarian law applies throughout the whole territory. You don't have to show any live nexus or actual connection between the armed conflict in question. That said, it actually did pose a serious impediment to the work of the Office of the Prosecutor in the post-war environment in the former Yugoslavia, particularly in relation to the aftermath of the Kosovo bombing, and when there was instability in Macedonia in 1999. We were particularly upset about that because actually, for reasons which no one fully understands, the ICTY statute actually imposes an armed conflict requirement on crimes against humanity, which is actually not required generally in crimes against humanity, which meant that Mrs. Del Ponte, the then prosecutor, went back to the UN Security Council and asked that the statute be amended and that requirement be removed. But unfortunately, the Security Council didn't respond to that. So I guess the only lesson to be learned from that is a prospective one, is that if you're ever called upon to draft a statute of an international criminal tribunal, don't. The thinking probably was, look, it's an innocuous requirement. Of course, all of these atrocities happen with an armed conflict. It's a no-brainer, but it did actually tie our hands. So the threshold is a meaningful one, and it is somewhat problematic. And I guess the solution nowadays, in terms of atrocities that might take place prior to the existence of an armed conflict or outside of that, is strengthened domestic rule of law, I guess. Then your question in relation to the notion of proportionality and the weighing, what means we have to enhance civilian protections in relation to permitted sort of attacks pursued in relation to military necessity. But I don't think there's, I think that's it really all depends on, to a large extent, on the value judgment made of the observers and the participants as to what level of civilian casualties are tolerable relative to the successful pursuit of military action. But I would but there is nonetheless very good jurisprudence from the ad hoc tribunals that does set out the contours of that to some extent. And you mentioned some of the Croatian cases before the ICTY, and queried some of the jurisprudence that might have suggested that, well, any attack that causes damage within 200 meters should be presumed to be unlawful. I'm not quite sure what case you're referring to. I doubt it's Gotovina. I suspect the case you're referring to is the Martic case, which actually was not so much referring to what form of lethal lethal range is permissible or not in relation to the deployment of a particular weapon, because I don't think that's the proportionality analysis is ever amenable to an equation like that. It would depend entirely on what weapon system you're talking about, what amounts to accepted professional standards in terms of the proper deployment of that weapon. But it is nonetheless expected that, unfortunately, even the most careful and legitimate use of weaponry in the context of an armed conflict can expect to create some civilian casualties. Instead, I think what the jurisprudence you're referring to was concerned the use by Martic of Orkan rockets, which were basically improvised devices that were just fired randomly into suburban Zagreb and caused catastrophic damage within quite a range. But the basis of the convictions there were not so much any arithmetic in terms of some sort of lethal range for that weapon, but the fact that this weapon was inherently incapable of being directed against military objectives, and therefore was by its nature unable to comply with the principle of distinction. In relation to other forms of weaponry, the question of whether or not the damage actually caused could have a hope of meeting the requirements of proportionality turned on very, very fine and complex technical evidence of weapons experts and counter experts sort of in the cases in question. And the final question regarding could civilian contractors be subsumed within a nation's military through a creative interpretation of two aspects of the Geneva Conventions? I have absolutely no idea. I can't point to any example from my own practice or experience to indicate to. All of the practice that I'm aware of to date tended to accept as a given a state's own depiction of what comprised its armed forces and what didn't. So I'm afraid I can't assist you greatly.
Thank you, panelists. Thank you, participants. On concluding and wrapping up, I would begin by suggesting that we have a look, in respect of the last question, to the Montreux document and the Montreux +5 document. I understand that you might be aware of the document, and your reference to the Geneva Conventions is poignant and perhaps worthy of great consideration, if not debate. The argument around Montreux is that the general principles of international humanitarian law apply to persons participating in hostilities, notwithstanding the fact that it might be governed by a private contract of employment. The Montreux +5 takes it further to look into the legal analysis of private military and contractual companies. Your question is well received, and it's something that we could engage further on, perhaps off the panel, at my pleasure at least. Ladies and gentlemen, the concept of DPH is not one that we can attempt to resolve at this panel. I leave participants and the panelists with a question, however. To what extent would even the most appropriate resolution of this concept of DPH bring effective change on the battlefield, where it matters most? The Attorney General referred to the heat of the battle, or the stress. To what extent is the armed forces officer, or even the member of the non-state armed group, apprised of these legal arguments, even in practice, to be able to know who is and who is not a target, to know what is and what is not a target? This, in my humble opinion, is the real effect of the law. I hope that these deliberations will take us one step closer to achieving that, both in the conference room and on the battlefield. Ladies and gentlemen, I thank you for your attention, and we look forward to welcoming you tomorrow for the remainder of this workshop. I now hand you over to Ms. Bakshi to deliver some comments.
I actually don't have any comments to offer. It's just that the Secretary General is going to give one set of our publications to His Excellency the Attorney General and the other one to Her Excellency, Head of Delegation of ICRC.
Ladies and gentlemen, thank you very much. We bid you a safe journey home and to see you tomorrow morning. Thank you. 9:30. Thank you.